Good morning and welcome to Employment Hour in 30. I'm John Scholes, my co-host, your co-host, Lior Samfiru from the Samfiru Tumarkin law firm here. If you've never caught the show before, this is your first time, Lior, what we do is we take an hour-long radio show basically and we drill down to the important stuff and give it to you in 30 minutes, some information you probably don't know, workplace rights and anything under that particular employment umbrella. Anytime you want to contact Lior privately, confidentially at the firm, it is help@employmenthour.com and the phone number is 1-855-821-5900. Again, confidential. Your calls will be taken forthwith. So what we do is start the week, Lior, all the time of the week that was, stuff that's been happening in the firm over the last week. So go ahead.
Well, you know, we've been doing the show for a while now, John, and a lot of people have been watching and calling me at my office with questions, and that's terrific. That's exactly why you and I are here, to inform and educate people and encourage them to make a call if they have a workplace problem. And I've been getting calls from people that being mistreated, harassed in the workplace. They wanted to know their rights. People who were let go, and they wanted to know what are their owed when they lost their jobs. I've had calls from people that were not getting paid overtime, and they wanted to know their rights. So if you're watching us right now, give me a call at the office. Let's talk about your rights. We're going to be here every week educating you and informing you, but if you want to talk about your specific situation, give me a call. Let's talk about that privately. Now, John, the week that was, I always like to start off with a case, some situation that I saw come across my desk over the past few days. Now, the matter I'll tell you about involved a gentleman. He was a marketing manager, and after 10 years of employment, he was let go because of a restructuring. Nothing that he did wrong, of course. Well, the company offered him 12 months severance. Now, 12 months was not bad. Probably slightly less than what I would assess him, but not bad. But here's the thing. The 12 months pay that they gave him, they calculated on the basis of his base salary only. Now, this gentleman, as an employee, also had a bonus that was worth about $20,000 a year usually. He had a car allowance, he had benefits, he had pension contributions that the company made, and the company did not include any of that as part of its severance, just base salary only. So when he came to me, he wanted to know, is this right? Well, John, it wasn't right. It wasn't even close to being right. Why? Because when it comes to severance, the company has to include and account for all components of compensation: salary, bonus, benefits, car allowance, etc., etc., etc. For him, these components over a 12-month period were worth about $40,000. So the message here is very clear. If you lose your job, it's not just about the number of months' pay that the company is going to provide you. It's what's included in it. If you have a bonus, that has to be accounted for, car allowance, etc. All components of compensation have to be accounted for, and if you don't get that, that is going to be a wrongful dismissal. So the devil is in the details. You have to be careful with what you accept, so don't just focus on the weeks or the months. You really want to understand that you're getting everything if you lose your job. Otherwise, you could be walking away, as this gentleman almost did, from tens of thousands of dollars.
Does he have to use all those components of his package for what they're worth? For instance, car allowance, does he have to, maybe he doesn't need a car now that he doesn't have the job, but does he have to go out and use that for a car, or it's just a dollar amount?
Excellent question. Because the company was paying him that amount, regardless of what he did with it, he gets that as part of his severance, even if he's not going to be driving, even if he's not going to need it. It's part of his compensation. It's a perk of the job. We give you $1,000 a month, whatever it is, as a car allowance. So that means that has to be included as part of the severance as well. So I've seen so many people over the years accept inadequate severance, not just because the number of months was wrong, but because they didn't have their benefits continued. Oh, and by the way, if you have a family and your benefits are going to get cut off, well, that's a huge problem. You really need to have those benefits extended for the full period of severance. So important to get that severance package review, John.
You know, I mentioned off the top of the show, we do a 1-hour radio show across Ontario for the past 4.5 years now. And people call in all the time, get lots of wonderful calls. Appreciate those. 1-855-821-5900 to call confidentially anytime. Lior or a member, his colleagues in the firm. We'll get to a phone call we had on that show previously.
For a company that is a federally regulated carrier, during the onboarding process, you have to sign an agreement that you recognize that they don't pay overtime. Now, if I leave either on my terms or their terms, am I entitled to overtime that I should have been paid?
Good question.
That's a great question. So if, in fact, the company was required to pay overtime but chose not to, the fact that he may have signed something saying, I don't get overtime, is meaningless. you can't contract out of your legal entitlements. So in this case, the Canada Labour Code, because it was a federally regulated company, if he's owed overtime because he's worked a number of hours to qualify for overtime, then the fact that he agreed not to take it means nothing. So that means that if he leaves, if he loses his job, yes, he can in fact go back for 2 years and pursue his entitlements, the overtime that the company should have paid him. Now, if they let him go, the severance that they're going to pay him we would also have to account for overtime he should have earned over the severance period. So that's very important when it comes to overtime. I want to make that point very clear. If you get overtime, the company has to pay it if you qualified. You can't agree to accept less than what you're owed. Usually for provincially regulated employees and employers, overtime is calculated as time and a half over hours over 44 a week, and it's payable whether you get a salary or hourly employee. You can't agree not to take that. And even if the company says we have a policy, we don't pay overtime, they still have to pay it. If they don't, you can go to the Ministry of Labor, you can call me. Overtime has to be paid.
I was just going to ask you that. Is this one of these instances where you are safe to call the Ministry of Labor, which we'll expand on in a minute, when you're not safe to call?
Yes, there are situations you should not call the Ministry of Labor. But when it comes to overtime, absolutely, it's perfectly fine to contact the Ministry of Labor. If you're owed overtime, if you're not sure if the company's calculating it correctly, yes, you can call the Ministry of Labor.
EmploymentHourTV.ca, online anytime, or you can email confidentially help@employmenthour.com as well. Want to get into this, one of the segments we want to cover today, and that is why people sign severance offers when they shouldn't. It's a massive list, but we've boiled it down to a few here. Number one is the shock of it all when it happens, right?
John, there's so many times that I've spoken hundreds and hundreds of times with people that have accepted severance offers and when they shouldn't have, and they call me after saying, is it too late? And usually, yes, it is. Once you've accepted a severance offer, it doesn't matter how bad it is, you can't go back. So I wanted to identify some of the reasons why some people may sign those severance offers that are inadequate so that you become aware of it. And if you're ever in that situation, now hopefully you would know better. Well, the main reason, I think, one of the top reasons, as you said, is the shock of it. So if you think about it, John, if I just lost my job, I'm being called into a meeting, now I have the rug pulled from under me, I don't have a job anymore, I'm worried about paying my bills, I'm worried about how am I going to pay for my kids' education, and you're offering me some money. And you're telling me that if I don't get this money, I'm going to, all of a sudden, if I don't accept it, I'm not going to get it. So with this whole shock of the situation, I'm probably not going to make the best decisions. And that's why people in that weakened state may accept severance that they shouldn't have. And I understand that. Unfortunately, despite the fact that it's so unfair, if you sign it, you have to live with it. Right. So I want people to start thinking about those things. Unfortunately, it's going to happen. Chances are in your lifetime, you may lose your job. And if that happens, despite the shock, despite the pressure, you need to make the right decision. You cannot, should not accept a severance offer without getting legal advice. If you do, you'll find out later you're owed tens of thousands of dollars more, and it will be too late.
Talking why people sign severance offers when they really shouldn't. A big one I know you get all the time is I don't want to burn any bridges.
Yeah. People believe that if I ask for more, if I try to pursue my entitlements, the company is going to be blackballing me in the industry. I'm going to burn my bridges. Well, John, first of all, people should never feel bad about pursuing what the law says they should have. If the law says you should be getting 12-month severance and the company is offering you 6 months, well, guess what? They're the ones doing something wrong, and you should never feel bad for pursuing your entitlements. That said, I'm very mindful of not burning bridges. My motto in life, you should always build bridges, not burn them. So because of that, when I approach a company on behalf of one of my clients that lost their jobs, I don't go in there like a crazy wild man making huge, ridiculous threats. I would rather approach them saying, we want to resolve this professionally and amicably. And not only do I not burn bridges, I also work on negotiating a letter of reference to help the person. So you should never worry about burning bridges. In all these years that I've done this, I've never had someone come to me and saying, because I pursued what the law says I should have, I burned my bridge. That should not be a concern.
Along those same lines, is it a reality that they might hear or might think to themselves, even without the employer saying it, that, you know what, you better take this 12 weeks pay because we're not putting this offer on the table again. In other words, if I don't take it, I'm going to lose it.
That's it. That's a pressure tactic. Right. Every severance letter, John, has a line at the end saying you have to accept this by this deadline, Friday, Monday, whatever the deadline is. And if you don't accept it, we're not going to pay it to you. So there's this pressure. Not only did I lose my job, I'm under this huge pressure. I don't want to not get paid. I got to pay my bills. But as I've said before, John, your rights don't expire Friday. That deadline is meaningless. If you're staring at a severance package, you have my blessing and my permission to ignore that deadline. Your rights are what they are. Okay, so take the time that you need to get proper legal advice. If it means taking another day, week, month, that's fine. Get that advice. That pressure tactic is going to have a negative impact on you, but you got to resist the urge to accept something that you shouldn't be accepting.
You want to contact Lior and the firm privately, 1-855-821-5900 or help@employmenthour.com. We're talking the reasons people sign severance offers when they really shouldn't. Another one on the list is contract terms, right?
Yeah, it's a lot of people believe that they may have signed an agreement that limits their severance, and some people have. But the reality is, John, in many occasions you can get around those agreements, those contracts that you signed. So some people would think, oh, I'm going to accept this severance package because of this employment agreement that I signed that limits my entitlements. I guess I'm stuck with it. And that may not be the case. So please don't ever assume that you're bound by a document without getting advice that says that you are. Call me, let's talk about it. Let's make sure that if you've signed an agreement that it's in fact enforceable. In many situations, it isn't.
Another reason people sign is because they unknowingly think, oh, I got a great offer. My Uncle Bob, my brother, told me that this is exactly, in fact, more severance than I should have got in the first place, which we know is probably not going to happen.
Good old Uncle Bob.
That's it.
And a lot of people, you know, this actually may be the most common reasons people accept severance that's inadequate is because they assume that it's fair. They assume that it's right, or maybe they assume that the employer must know what it's doing. Well, let's get rid of that idea, of that notion, John. 90% of people accept inadequate severance. 90% of people are offered inadequate severance. So if you're staring at a severance letter 9 out of 10 times, it's completely inadequate. And there's no excuse to get advice from someone that's not an employment lawyer. You're not going to get medical advice from someone that's not a doctor, right? You're not going to call your Uncle Bob about your medical condition. So you get advice from a lawyer. The Ministry of Labor can help you. We touched on that earlier. They can only advise you with respect to your minimum entitlements, which is only a small fraction of what you're actually owed. So again, you lost your job, get proper advice. Call me, go to severancepaycalculator.com. We'll touch on that a bit later. Make sure you actually understand what you're signing. Don't make any assumptions.
Again, why people sign severance offers when they really shouldn't. This one, number 6, I guess, the entire severance process. They figure that it'd be in court, and it's going to be messy and dirty and long.
Well,
right?
you know, Lior, you tell me I'm owed more severance, but man, it's probably going to be so difficult to get it. I'm going to have to do all these legal maneuverings. It's going to take time. Well, you know what, John? When it comes to employment disputes, the vast majority of them resolve very quickly. They resolve amicably and often without any illegal action. So unlike other disputes, personal injury claims, divorces, etc., which could get complicated, long, and expensive, that's very different in the employment law field. Usually we can resolve it quickly with a letter or two, and even if legal action is required, oftentimes we can resolve it very, very quickly. So people should never be afraid of the process. No one should ever accept less than their own because they're scared of the process. At the very least, make a call and find out what that process is going to be.
That number, confidential, is 1-855-821-5900. Get a hold of Lior and the firm, or help@employmenthour.com. That's the email as well. Totally confidential. Use it right now if you want. We mentioned 2 points ago the severance offer being inadequate. So people are saying, well, how do I know if it's adequate? Even before calling you. Severance Pay Calculator, right?
Severancepaycalculator.com is a tool that I created to help everyone and anyone educate themselves on what they are actually owed, John. It's a free tool, and I wanted people that may be a bit uncomfortable speaking with a lawyer, or not sure if they should, to still have access to that information. So it's a very important tool. You go to severancepaycalculator.com. Again, severancepaycalculator.com. You answer 3 simple questions. It's going to take you 10 seconds flat. You answer what your age is, the type of job that you have, and the length of your employment, and you're done. It's going to tell you whether you're owed 2-month severance, 24-month severance, and here's a neat experiment you should do. Maybe you haven't lost your job, but put a number in your head in terms of what do you think you'd be owed if you did lose your job. Write it down on a piece of paper, and then go to severancepaycalculator.com. Input your information and find out what that number is. I would be shocked if anyone watching us right now, John, the number that they wrote down is as much, if it's even close to what they're actually owed. And it's not because there's a bug in the system, it's because that's what a person's entitlements actually are. So I want to make it very clear, severancepaycalculator.com, always the very first place you go to if you lost your job. And if you're talking with your neighbor down the road and you know they lost their job, again, tell them to go to severancepaycalculator.com.
We'll take a short break. Emails confidentially, help@employmenthour.com. That phone number that Lior keeps mentioning, 1-855-821-5900. We'll deal with workplace harassment, and we'll get to another phone call that we've called from our 1-hour radio show that we do here across Ontario as well. It's Employment Hour in 30 on Global. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
You know someone that's been let go, tell them to go to severancepaycalculator.com. You have the right to have that information. It's not what the employer wants to pay you, it's how much you're actually owed, and the place to go to, severancepaycalculator.com.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Employment Hour in 30 continues here. If you're not familiar with the radio show, we do that for an hour across Ontario for about 4.5 years. We've been doing that. Confidential phone number, and they use it and they call in as well, 1-855-821-5900 and help@employmenthour.com through confidential email. Let's get to one of the calls that we've got from the radio show.
I'm calling on behalf of my sister. She's unfortunately being sexually harassed at work. 2 of her male coworkers are doing it. And it's been escalating over the last couple of months. It's gotten to be pretty nasty stuff. She hasn't said anything yet to her manager, but she's worried if she does, if this will just make things worse and these 2 coworkers will just get nastier. Should she complain? Should she just quit? What are her rights here?
Yeah, well, what a difficult situation, John. And I've spoken with so many people. I speak with people every day in these types of situations, whether it's sexual harassment or other harassment. And when you're being harassed at work, definitely sexual harassment, it's going to impact you. It's going to impact your health. I've seen individuals go off on medical leaves for very long periods of time because of that harassment. So it's a very bad, very difficult situation. So let's start off with what the law says. The law says that every employee has a right to work in a harassment-free work environment, and it's the employer's responsibility to make it so, to ensure that the work environment is proper, that it's not poisoned, that it's supportive and conducive to working. So if you're working in a situation where you're being harassed, that work environment now is not the way it should be, that's wrong, and there's legal measures. What I always say is you want to try to resolve it internally, at least as a first step. So to the caller that we had on our radio show, what I say is, yes, have your sister speak with someone at the company. Maybe it's the owner, maybe it's the human resource manager, and give them an opportunity to fix the problem. They should be aware of it. You shouldn't be shy. They're not allowed, by the way, to penalize you in any way for raising a harassment complaint. So you speak with them and you give them an opportunity to fix it. That may mean removing you from that situation. That may mean penalizing the other person, maybe letting the other person go, but you have to give them an opportunity to fix it. Now, if you've given them an opportunity and either they haven't done anything or they haven't done a good enough job, then we can deal with it externally. What I mean at that point, you may have recourse as a constructive dismissal. We may be able to get you out of there with your full severance. There could be also remedies under the Human Rights Code. You may be entitled to other damages because of the fact that you've been sexually harassed. So the law will come down pretty hard on an employer that doesn't fix the problem, that allows workplace harassment to continue in the workplace. So I want all of our viewers right now, if you're dealing with harassment in the workplace, please understand that you have rights and you have recourse. I want you to speak with your employer and give them an opportunity to fix it, knowing that you cannot be punished. You cannot be penalized in any way for doing that. Obviously, if you are punished, you call me. But if once the employer knows about it, if they don't fix the problem, if they don't do a good job, I want to speak to you. I want to help get you out of there, get you the compensation that you're owed so you don't have to suffer anymore.
Someone's got to be thinking, okay, I get that if it's a colleague that I work with harassing me. What if it's the boss and they're the person I'm supposed to go to and complain to, right?
In some situations, John, of course, it's going to be impossible to go speak to someone because it's the boss or the HR manager, whoever it is that's actually doing the harassing. In that situation, of course, it makes no sense to go and complain, and we would have to deal with it externally. At that point, we are best off to extract the person, to get them out of there and get them severance, get them any remedies and rights and compensation that they're owed under the Human Rights Code, and move it that way. But if possible, only if possible, I want to try to get it resolved internally. If it's not possible, or if you've tried and it didn't work, then we got to get something done from a legal standpoint.
Should an employee do it differently if it's based maybe not on sexual harassment, but if it's based on religion or race or being pregnant, anything like that?
It doesn't matter. Maybe you're being harassed, not even for any discriminatory reason, maybe because someone is just a jerk, okay? These things happen, John. It doesn't matter what the reason for the harassment, who is the one harassing you, what the basis is. You have a right as an employee to work in a harassment-free environment, full stop. So if you're being harassed, you got to do something about it. Don't just suffer in peace. Don't just be quiet about it and hope that it's going to go away. It's not going to go away unless you do something about it. So try to speak with someone at the company. Try to get it resolved that way. If it doesn't get resolved, or if that's not possible, I'll help you.
EmploymentHourTV.ca, anytime online, and that confidential phone number as well, Lior or a member of his team, 1-855-821-5900. We also have a website called wrongfuldismissalquestions.com. Get a ton of these every week. You know, daily you get all kinds of questions coming through. I want to read one and let you get down on this one. It says, I was terminated after 6 months of employment due to an alleged sexual comment. No prior warning. Employer has offered me 2 weeks termination pay. I'm 68 years old.
You know, obviously the devil's in the details, right? So I would want to know what the sexual comment was. I'll say this, it's very difficult to terminate someone for cause because of one comment, unless it was pretty bad. So assuming this is not cause, and it's probably not, then the person would be owed much more than 2 weeks pay. You know, after a couple of years, they could be owed as much as 6 months pay. So it's very difficult to terminate for cause, John. I want our viewers to remember that. You may have done something wrong, and if this person made an inappropriate comment, well, guess what? That's something that they could be disciplined for. But the fact that you could be disciplined does not mean, it absolutely does not mean that you could be fired. Being fired for cause, it's the death penalty. It's the ultimate last penalty reserved for the worst offenders. So many times someone may get let go, not because there's cause, because they did something wrong and the employer jumps the gun. So you're not allowed to jump the gun if you're the employer. You got to follow a process. So if you lost your job, but what you did does not rise to the level of cause, as it doesn't in most situations, you're owed full severance.
First part of the show, we talked about in detail severance pay calculator, how it works, what it does. But I want to give put a scenario out there to show people exactly what it comes down to.
So let's look at a scenario, John. This is a scenario that would involve a short service employee, and it's just based on something that I came across my desk recently. So let's look at someone with 2 years of employment. So maybe someone that's 43 years old in a middle management position. I put in a salary of say $80,000. So someone like that may think, after 2 years of employment, I'm not owed much. It's only 2 years, and they may well be offered only 2 weeks' pay. But I can tell you, and the calculator will show you if you use that someone in that situation could get anywhere from 4 to 6 months' pay. And that's, if you're offered 2 weeks, that's an additional $25,000, $30,000, $35,000. It's a big difference. So again, 2 years of service, you're potentially looking at 4, 5, 6 months of pay. And I assure you, if you lost your job after 2 years, you probably are going to be offered 2 weeks, 3 weeks, 4 weeks if you're lucky, a lot less than what you're owed. That's why it's so important to use the severance calculator. And again, you may not have lost your job, but you're concerned about losing your job. Or maybe you're just curious. Again, severancepaycalculator.com.
Confidential phone number anytime as well, 1-855-821-5900. We'll take a short break here. We'll get to a phone call that came through the 1 hour radio show, which we've been doing for about 4 hours here in Ontario. We'll get to one of those. And we'll also talk about returning to work after an accident as well here in the Employment Hour in 30.
Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
We continue with the Employment Hour in 30 here on Global. If you haven't caught the radio show for the last 4 years, we've been doing that. The phone call is 1-855-821-5900. We take on the radio show. We'll play back one we had recently.
I work for a food company. When I signed on with the company, I signed a non-compete. If I resign, I'll give my 2 weeks and go to another company. Can they stop me from working? Or if they let me go and I go to another company, can they stop me working? From what I heard for the law is they cannot stop you from making a living, and it will not stand up in court.
The old non-compete.
The old non-compete. And you and I have got many calls like that on our radio show. I've gotten a ton of these calls at my office. People asking me about the enforceability of non-compete clauses. So let me answer it. Let me educate hopefully some of our viewers now. So for the most part, non-compete obligations, non-compete clauses are not enforceable. As the call said there, our courts have decided that they don't like terms that prevent people from earning a living. So unless you're in a very high executive level position, it's not going to be enforceable. So you may think, okay, great, it's not enforceable. Who cares? Let's move on. I can just do whatever I want and ignore it. Well, not so fast. The reason I say not so fast is the question you should be asking yourself is not, is the non-compete enforceable? The question you should be asking yourself is my former company going to try to enforce the non-compete? So if your former company is going to try to enforce it, what are they going to do? They're going to take legal action against you if you go work for a competitor. They may sue your new employer as well, and they can make your life miserable in the process. Now, at the end of a very long and expensive legal process, you're going to win because, as I said, it's not enforceable. But your life in the meantime can still be very miserable.
Long and expensive.
Long and expensive. Now, why would a company do that? Why would a company try to enforce a non-compete that it's not enforceable? Well, one reason may be to send a message to the other employees that this is what happens if you leave us and you ignore your non-compete. So it's not enough to say it's not enforceable. You may still run the risk of engaging in a long legal battle. So if you have a non-compete and you've signed that non-compete, you have to take it very carefully. You can't ignore it. If you ignore it, you run the risk of getting sued. So the better approach would be, John, if you have a non-compete and you're wondering what to do, is talk to your company, talk to the former employer, and see if you can work out with them that they're not going to enforce it against you. Maybe you promise them that you're not going to solicit their clients, you're not going to disclose their confidential information, but that allow you to work wherever you need to work in order to earn a living. But you can't just ignore it. If you ignore the non-compete, you have a problem. And of course, if you're ever in a dispute with your company, if they're threatening to take legal action against you because you breach a non-compete, man, that's when you have to call me right away.
You can email Lior and members of his colleagues of his firm, rather, help@employmenthour.com anytime, completely confidential. We'll get to an email from Dave, says was injured in a car accident and his boss refused to take him back unless he was 90 to 100% of previous capabilities. He was not given any opportunity to prove his abilities during a workplace assessment. He worked for the company for over 7 years. Is he owed severance?
Yeah, he's owed severance and potentially more, John. And the reason for that, a company, an employer has an obligation to provide accommodation. We call this a duty to accommodate. So if you're injured, if you have a disability, and you may not be at 100%, the company has to provide accommodation. That may mean changing your job, giving you modified duties, maybe modified hours. That may mean relocating you to help you out. There's really no finite list. There's potentially a lot of things the company would have to do to help you. Now, they can't arbitrarily say, we're not even going to look at you unless you're 90% at least well enough to come back to work. As long as they can provide accommodation, whether you're at 20% and 30 or 50, they have to do it. So in this situation, it certainly sounds that a company that were to say, you have to be at least at 90%, are breaching their obligations under the Human Rights Code. So not only could that be a termination by saying, we're not going to take you back unless you're at least 90%, by even saying that, that's a violation of the Human Rights Code. So I want our viewers to understand that your employer has to provide that accommodation, even if it's difficult. Some employers may say, well, it's going to be a bit difficult to accommodate you. We'll have to find another role for you. It doesn't matter. Even if it's difficult, you have to do it. Now, at some point, it can get to be way too difficult, and that may mean the company doesn't have to accommodate. But in most situations, they have to accommodate, John. And if they impose conditions, if they refuse to do it, if they don't try, that's a wrongful dismissal. That's a violation of the Human Rights Code. The law is going to come down pretty hard on the employer, and you have to give me a call.
And always consult your doctor as well, because they have the trump card, right?
Yeah.
So you can return or not.
If you need accommodation, have the doctor say it, and maybe make it the doctor, or have the doctor make a recommendation. So maybe you can't lift more than 30 pounds. Have the doctor say that. Maybe you can't stand for more than an hour at a time. Have the doctor say that. And that imposes the obligation on the employer to try to fix it and to try to accommodate. And again, if they don't, that's a big problem. That's illegal.
Good for another week. In closing, the phone number confidential anytime, 1-855-821-5900. You can email Lior and his colleagues as well, help@employmenthour.com. Again, confidential. We read them on the show. We play the phone calls back. And employmenthourtv.ca if you want details of what we talked about today in past shows and how to link up to our 1-hour radio show as well across Ontario. You can do that as well. Till next time, Lior, we'll do it again next week.
We'll do it.
Saturday right here. It's the Employment Hour in 30 right here on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com.